all had a good Diwali. Yes.
This is Lordship. Actually, I beg to mention item number 3, Lordship. We are on this matter for the delay of Lordship.
Item 3, what do you want?
Adjournment, Lordship, for the day.
Why?
Lordship, my senior is out of station, Lordship.
As prayed for by MS.
B does on behalf of M. Kolita.
B does Learned Counsel for the petitioner list after
1 week, Lordship.
relist after a week on a date to be fixed by the registry.
Lordship,
Yes.
In this case, I am for the respondents.
You have an objection?
No.
Yes.
Mr.
If you want your names to be recorded, give it to the court master.
No.
Yes.
40 would like to adjourn the matter for today.
Item number?
40. We have prepared and written submission. Note.
Hmm?
We have prepared and written submission or note.
Hmm.
Would like to submit it today itself.
You can submit, but you don't need a permission for that. What is your prayer?
To adjourn the matter.
To adjourn. Yes, there is no difficulty. I can adjourn item 40, but if you want to submit something, you can go ahead.
Okay.
You
Thank
give it to the court master if it's a written argument, or you can give it at the time when the matter is called. Right? You are for the petitioner. And who's for the petitioner? Have you taken consent? Have you taken consent from them? As prayed for by Mr.
RC Alam on behalf of Bhatin.
R.C. Alam on behalf of
Bhatin words.
Learned Counsel appearing for the Guwahati University with consent from the other side, relist after a week
Lordship, if possible, fix the matter on 29.
on such and such date. Mr. Sharma, I think in this matter, you are appearing item 40. No objection?
No objection, my lord, for a date that is sought.
And they are, I think, going to submit some written argument. So you give a copy to Mr. Sharma as well as to the court master.
Good.
Okay.
My lord, I beg to mention item number 1, my lord. Today I have some personal difficulties because of.
When? Because it's an old matter. So give me a short date.
Yes, yes.
When? When do you want it?
And for November.
You are for the other side.
I'm.
As prayed for by Mr. S.K. Ghosh, which is Learned Counsel for the petitioner, which is not objected by the other side, relist on such and such date.
No, but November already fixed another.
Please sort it out there. Yes, next.
My lord, I beg to mention item number 8, my lord. With consent of the my lord, the other respondents council, my lord, SC Railway, my lord, V. Sharma, my lord. My lord, matter may pass over for the day, my lord.
You are for the petitioner.
Petition.
As prayed for by Mr. L.N.
Lord.
Dhingia, Learned Counsel appearing for the petitioner, relist after
1 week
2 weeks on a date to be fixed by the registry.
of life.
Yes.
May I please, your lordship, with the consent of the other side, I beg to mention item number 33. We will, in this case, we will file an.
It's all right. You speak slowly.
Yes, sir. We will file an affidavit in opposition. So 3 weeks time maybe.
You want 3 weeks time in item number 33.
Yes.
You are for the petitioner or for the respondent?
Respondent.
I am for the petitioner.
You are for the petitioner. No objection.
No objection.
As prayed for by Mr.
A. Goswami.
A. Goswami, Learned Counsel appearing for the respondent with consent from relist after 2 weeks to enable the respondent file counter in the matter, which is not objected by the other side. Yes.
Lordship, may kindly fix it for admission since.
All right, it will come and then we will fix it. Yes.
Please, Your Lordship, I beg to mention item number 9. As per last order, we were supposed to make some correction in the memo of appeal, but we could not make. So kindly 2 weeks time be given, Lordship.
To make some corrections, your MS Tinglung. As prayed for by MS Tinglung, Learned Counsel appearing for the appellant, relist after a week on a date to be fixed by the registry to enable the appellant do the necessary correction as it was directed earlier, at order to Siloma. Yes.
May please, your lordship. Lordship, I beg to mention item number 31, lordship.
What do you want?
We're seeking an adjournment in this matter for 2 weeks, your lordship.
I'm being liberal today, being the first day after the Diwali, but next after today, I will not be so liberal granting adjournment in all my matters. What do you want in 31?
Lordship, 2 weeks time.
2 weeks time. You are for the appellant.
Yes, your lordship.
As prayed for by Mr.
N. Sharma, your lordship.
N. Sharma, learned counsel appearing for the appellant relist after
2 weeks.
2 weeks on a date to be fixed by the registry to N. That's it.
Deeply obliged.
Yes.
On admission item number 2.
Yes, Mr. Datta.
This is a landlord tenant matter,
It's a
landlord and tenant matter.
yes. Mr. Iqbal is objecting.
Yes.
Not of the, let
Ah.
it be admitted.
It's a CRP.
CRP. My learned friend, he is appealing for the landlord.
In fact, it can be disposed if you're.
What is the issue?
The issue is regarding that we filed a petition for eviction of the respondents, also recovery of area rent and khas possession. Now.
Eviction and
Eviction, recovery of area rents and khas possession.
yes.
So we filed this suit. Now both the courts below have dismissed my claim, saying that the due
This is
date
under 115.
under 115, yes.
So what is the material irregularity committed by the
Courts below.
by the trial court?
The trial court said that due date for paying the rent that was not paid within the due date could not be for payment of
There
the
was a
rent.
default.
There was no. He was not a defaulter. The respondent tenants was not a defaulter because the due date could not be ascertained. So due date is an important concept as per Assam Urban Area Rent Control Act. So usually within a fortnight of the due date, the tenant has to deposit the amount with before the court if the landlord does not accept it. So the
According
date-
to the trial court, the due date is not ascertainable.
is not ascertainable because there was an agreement, oral agreement between both the parties initially. That was a monthly agreement. And as per that agreement, on the 7th day of every month, the rent used to be paid by the respondents. Now thereafter, after a period of about 11 to 12 years, it got converted to yearly tenancy. Earlier it was monthly, then it got converted into yearly. So there it was ascertained by both the parties that the rent will be paid at the beginning of Durga Puja, first week of October.
This was in some agreement.
Orally.
Everything was orally, yes.
Or
And that has been admitted by the tenant in their WS as well
Evidence.
as the evidence. yes,
Evidence.
Yes.
now, Mr. Datta, enlighten me whether an oral agreement here will stand valid for ascertainment of a
that
due
would be
date.
valid. There is one decision.
Because I think that would be the moot question
Yes,
then,
yes, yes.
because I don't think that position is disputed, right, Mr. Iqbal?
My lord.
That there was no due date prescribed in any written form
Any
of
written-
contract, but nonetheless, parties have orally agreed, initially monthly, then yearly, and then you said
In the month of October.
October before the Durga
But
Puja.
both the courts have come to the conclusion, since the rent used to be collected sometimes for September, October, November, December, so the due date could not have been ascertained, my lord. Because he used to collect as per his own convenience, my lord.
All right, then I think I was trying to see if can be disposed of today itself. It might take a little
And,
bit
there
time
is
then.
another point of law
Uh,
that the rented premises was required by there was a bona fide requirement.
So that was
was-
rejected.
That was
not
waived by the-
rejected. That was waived, yes. Because earlier I said that was required by my son, but he expired during the course of the
So
proceeding.
then no
But-
need to go to that.
No, but there are case laws saying that the bona fide concept of bona fide requirement is a dynamic concept. So from the date of filing the suit, this bona fide requirement remains until the entire matter is disposed of.
Correct, but
Yes.
you see, if in the meantime the
Yes.
son has expired, then that requirement becomes obsolete.
No, because my
Plus,
family's
yes, wait.
requirement is there.
Huh?
My family's requirement is there.
Yes, and
Because-
I haven't opened the brief, but
Yes.
Mr. Iqbal says that you have waived it.
I have waived, but still it remains as per certain decisions of the apex court. I've got that.
All right, when do you want it? We can have it for
On a
for
hearing.
final disposal.
And that regarding oral agreement also I'll bring.
You get all that.
Yes, yes.
When? Thursday?
Thursday tomorrow,
Yeah, no, today is Tuesday.
Wednesday,
Sorry, Wednesday.
next Tuesday.
I think that will give you sufficient time to get all the decisions. Heard Mr. S. Datta, Learned Counsel appearing for the petitioner, as well as Mr. A. Iqbal, Learned Counsel appearing for the respondents. I'll admit it and post it for hearing on that day. Huh? The matter requires a full-fledged hearing. Admit for hearing, post on such and such date, Tuesday date to date. Yeah. As first item in the hearing column. Deeply. এটা মনত পেলাই দিব মোক।
May please your lordship. My lord, this revision petition is directed against the two orders.
Yes, Mr. Sikdar,
My lord,
it is directed against.
my lord, there are two orders.
No, there is no representation only for 1 and 3, Ms. Chaudhary. 4 and 5 deemed served, they have not appeared.
1 to 3, I may be.
Yes, 1, 2, 3 were. Yes. What is this?
My lord, here the petitioner filed a title suit, paying for right title, interest, and etc. And the suit was decreed. The other side has filed appeal.
Yes.
Their appeal was not admitted. And there was a delay. They have filed two petitions, one for condoning the delay
Mhm.
and other for execution for suspending the execution proceeding initiated by the judge decree holder, the petitioner. And these two petitions, there has been two orders, and both the orders have been passed behind our back. That is our grievance, my lord. Kindly have a look at, my lord, the order in the execution, like miss case number 3.
Chaudhary, I'm admitting this and putting it for hearing.
Lordship, stay was already vacated and my appeal is
My lord.
pending. My condemnation petition is.
Yes, but this has come for admission, so I'm
Yes,
admitting it
My
and
lord,
posting it for hearing.
Since my prayer is only to let this court below may be directed to pass fresh order after hearing the petitioner. That is my limited prayer, my lord. Both the orders have been passed behind our back,
Show me that order.
my lord. At page first order, lord, you will find at page.
Are you agreeable to that order?
Lordship, stay was granted in.
No,
favor
no,
of us.
disposal on the fact that they, after hearing, they can dispose it afresh.
No, Lordship, already.
Then I'm
there-
admitting it and fixing it for hearing.
My
Heard Mr. A.R. Sikdar, Learned Counsel appearing for the petitioner. Also heard M.S.R. Chaudhary, Learned Counsel appearing for the respondent. The matter requires full-fledged hearing. Admit list for hearing in the month of November on any date to be fixed by
My
the
lord,
registry.
date may be fixed, my lord.
It'll come, Mr. Sikdar. Yes, next.
Right.
Mr. Biswas, who is appear? You are for the petitioner?
No, I am for.
Respondent.
Respondent, the claimant, my lord.
It's a MAC appeal.
Yes.
You are the appellant.
No, the insurance company is the appellant.
Where is the insurance company?
I am for the owner.
No, but who is the appellant? The appellant side is that side. You are standing in the
Yes,
appellant
that's
side. That
right.
is why I'm getting confused. So none appears. This has come for the first time or no?
No, my lord. No, my lord. Earlier it was listed.
None appears for the appeal on call. Mr. S. Biswas and as well as Mr.
RKJ.
R.K. Jain, Learned Counsels appearing for the respondents are present. Relist after 2 weeks on a date to be fixed by the registry.
6.
This is your lordship.
Yes, Ms.
Lordship, this is
Majumdar.
a Statutory appeal, filed by the insurance company, Lordship.
Admitted or not admitted till now?
No, not.
I'll
admitted.
admit it. You must have already deposited that 25,000.
Yes,
You are appearing for the respondents.
Why? Why?
Heard MS.
Lordship.
Yes.
May I submit? Your Lordship, on the last occasion, my prayer was that the appeal may be admitted subject to condition that they deposit 50% to.
But they are not seeking any stay.
But even in absence of.
They have
stay-
already given 25,000,
No,
25,000 or 50, whichever is less. 25 they have already given.
That is a statutory deposit, that is refund.
Correct, and now they are not seeking for any stay. It's a statutory appeal. I'm admitting
So
it.
your lordship may record that there is, since no stay has been preferred, so there will be no bar to the item.
No, I'm not going to do it.
In the appeal.
Ms. Majumdar, please, heard MS R.D. Majumdar, Learned Counsel appearing for the appellant. Also heard Mr. D. Mondal.
Yes, your lordship.
Mr. D. Mondal, Learned Counsel appearing for the respondent, sole respondent.
No,
No, your lordship.
they are from the same family actually. One and
No,
two.
but Mr. Mondal, who are you appearing
I am
for?
for respondent number one.
Only one.
One.
Two, we will take step.
For respondent number one. Stop. This appeal is presented under section 173 of MV Act 1988 against the judgment award dated 7/7/2023 passed by the learned member MACT Nagaon in MAC case number 241 2000 stroke 2008 18. The requisite statutory deposit of rupees 25,000 appears to have been deposited in the registry of the of this court. Perusal of the appeal memo indicates that this being a statutory appeal, admit for hearing. Mr. So-and-so accepts notice on behalf of respondent number one, steps by registered post AD in respect of respondent number two within 3 days. Extra copies and steps.
Served, Lord.
Extra copies to Kuba. Mr. Mondal have confirmed that extra copies have been, extra copies waived and steps by registered post AD within 3 days.
May I please, your
Yes,
lordship?
maybe call.
Call for the records from so and so, huh? And list.
May I please?
This has come for admission, right? List for hearing after receipt of the records. In the meantime, you want something, you file an application. Yes, next.
Oblige.
May it please, your lordship. My lord, this matter, only, my lord, the respondent side is Mr.
Mr. Datta, it's a statutory appeal.
Yes, yes. The other side, my lord, he could not be present. He called me last night that he's out of station. So I said, send some of your junior. Possibly he could not send anybody.
No, but it's for admission, I'll admit it.
Yes, it's a admission and then, my lord, subject to payment of 50% of the awarded
For
amount.
that, we
But
should have. So
I
can we
said
have it tomorrow? Will he be there?
tomorrow,
Because
he said Friday, my lord. Your lordship
Um,
can fix it on.
all right. Heard Mr. S. Datta, learned senior counsel, assisted by Mr. S. Datta, learned counsel for the appellant. None appears for the respondent, despite, but notice is served, no?
Yes, yes, he appeared already.
No, there is, I think today is the first day. There is no appearance. The name is appearing here. This is item
Yes.
number.
Mr. Item 7, Mr. Devnath. Is it?
None appears for the respondent despite the name of the learned counsel, Mr. N. Devnath, being reflected in the cost list. Relist on Friday, such and such date. Friday, okay?
Yes, of like.
Yes, Mr. Bhatta. What is this? MAC appeal? First time?
First.
So I'll appeal, admit it. This is heard Mr. A.K. Bhatta, learned counsel appearing for the petitioner, appellant. This appeal is presented under section 173 of the MV Act against the judgment and award dated 3/5/2025 passed by member MACT Kachar at Silchar in MAC case number 367 of 2022, whereby the appellant insurer was directed to pay a sum of rupees 21,46,400 with interest at 9% per annum from the date of filing claim petition till final payment. Stop. The requisite 25 is given. Yes, yes. The requisite 25,000 deposit has been made before the Registrar General of this court. Admit, issue notice to respondents by registered post AD, steps by within 3 days, call for records.
I for the still also.
There's a IA.
Yes.
So IA, we will take it up on in the IA also issue notice and give a date after 2 weeks. Let them come and then we will. Issue notice koi bade IA to do. Substantial question of law.
My lord, here in this case, my lord, there is one more RSA, my lord.
Huh?
Out of the same,
That is not listed today.
my lord, this matter may kindly be tapped with.
Yeah, I've understood. So I'm asking you, the other connected regular second appeal is not on is not on board today.
My lord,
Is it correct?
Yes.
You're Mr. Bharadwaj, right?
AC sir.
AC.
AC.
Mr. Sharma, then I'll list this with that. Heard Mr.
Era.
A. Raman, Learned Counsel for the appellant, also heard Mr.
AC.
A.C. Sharma, Learned Senior Counsel, assisted by B. Deori, Learned Counsel for the respondents, sole respondents.
No.
All the respondents. You're appearing for all the respondents. Respondent number 1 and 2. Office note dated 35/2025 indicates that AD cards have been received from proforma respondent numbers 6 and 7. However, neither AD cards nor unserved notices have been received from proforma respondent numbers 3, 4, and 5 till date. It is submitted at the bar that the connected regular second appeal being RSA 36/23
23.
is not listed along with the instant appeal. Relist along with so and so with up to date office service report. On after 2 weeks, I'll make it after 2 weeks because the respondents have not been after 2 weeks on a date to be fixed by the registry.
Obligation. 12.
Yes.
Lordship, I'm appearing for respondent number 1.
Last time also there was no appellant,
Yes, Your Lordship.
no representation. What to do? This is statutory appeal. No.
There was a direction for taking states upon respondent number 2 and 3.
That is also not done.
No, Your Lordship.
None appears for the parties when the matter is called. This is item number
12.
Parties no ko baha. None appears for the petitioner. Despite the names of 3 counsels, Mr. C. Kalita, Mr. L. Kalita, MS S. Das being reflected in the cause list. MS
P. Borthakur.
P. Borthakur, Learned Counsel, is present on behalf of the respondent number 1.
Respondent number 1.
Number 1. It further appears that on the last 1, 2, 3 consecutive dates, i.e. 18/8/2025, 21/4/2023, as well as on 5/3/2019, there was no representation on behalf of the appellant. Stop. MS so-and-so further submits that, yes, you said they have not taken steps. They have not further submits that the appellant, despite the order dated 5/3/2019, has not taken fresh steps for service of notice on respondent numbers 2 and 3 by registered post with AD as well as by usual process don't say within usual process. Stop. Relist on such and such date, the date depot, with intimation of the next date to the aforesaid to the 3 learned to the learned counsels on record appearing for the appellant through email through WhatsApp message by the registry.
Item 13.
May it please your lordship.
Yes,
In this matter, my lord, dispatch section returned the notices because there was a shortage of stamp. My
Oh,
lord, we may be allowed to, in the course of the day, we shall replenish that.
yes. Mr. S. Datta, Learned Senior Counsel, assisted by Mr. S. Datta, Learned Counsel for the appellant, assures that submits that since the
Your lordship will find that at 3/9/2025.
Hmm, three-
Office note dated 3/9/2025.
since notices since service notices has been returned back from dispatch section due to shortage of stamp, his office shall take the requisite steps immediately. In view of the aforesaid assurance of the Learned Senior Counsel, relist after 2 weeks on a date to be fixed by the registry to enable the appellant clear the defects, to clear the defects and take steps as directed earlier by this court.
14.
Yes,
Please,
Ms.
your lordship.
Devi?
The matter has come before your lordship as per Lozama Court's order minor that was passed on 14th October 2025 regarding service of notice upon response number 5 minor. But in the meanwhile, what has happened, my lord, the suit was decreed by the trial court in the year 2009. Ejectment decree was passed, and subsequently when the appeal was preferred by the second appealant, the appeal was dismissed. Against that, we have come. So it is barred by limitation. So this 3976 is for condonation of delay and 3978 is for stay after hearing under order 41 rule 11.
But now the IA is not being able to proceed because of respondent number 5.
Yes.
There is an office
Respondent number
note
five,
of 1 September per September. It says despite from the office note dated 19/2/25 and 29/8/25, it is discernible that notice was issued to R5 by registered post on such and such date. But in regard to the aforesaid notice, it appears that neither the AD card nor any unserved notice has been received. Despite the aforesaid, it has been observed that the postal, Ms. Chaudhary, please hear this. Despite the aforesaid, it has been observed that the postal track consignment report regarding the notice issued to the respondent mentioned above is available with the case record, which shows that the notice in respect of R5 has been delivered. So I think we can deem service.
Yes, but I have another submission, my lord. But since the ejectment decree was passed, I tried to contact my client regarding the status of the suit property. And I've been repeatedly calling and I have sent letters under registered cover. But no response has been received as yet. The letters from the earlier letter, it was received, tracking report. But subsequently, when the second letter was issued, the tracking report has not come. I mean, I am facing a predicament because if the suit property has
No, but what do you want this to
yes,
do
I
now?
want some time so that I can.
That is all right. I'll adjourn. In any case, I have first, let me deem service for respondent number 5 and post the matter after 2 weeks. In the meantime, you try whatever contact you can do. Heard MS B. Chaudhary, Learned Counsel appearing for the appellant. Also heard MS M. Sahu, Learned Counsel appearing on behalf of respondent numbers 1 to 4. Office note dated 1/9/2025 appears that the AD card indicates that notice in respect of the respondent number 5 has been delivered to the addressee on 25/2/2025. Stop. Where service as such stands complete. Relist after 2 weeks on a date to be fixed by the registry.
તો ગુંપુને અથવા પેક છે.
Yes, Ms. Majumdar.
I'm appealing for respondent number
Hmm.
1.
None appears. On the last occasion also, I think nobody appeared.
Yes,
It has statutory appeal. I mean,
already I think it is admitted lorships.
yes, it's admitted. So I'll post it for hearing. But what
Yes.
about records? Records, are here? Records have come. None appears for the appellant on call, MS RK Chaudhary.
RD Mujumdar.
R.D. Majumdar, sorry. R.D. Majumdar, Learned Counsel, is present for the respondents. It appears that the records of the trial courts have been received. List for hearing on in the month of Vidya. When, Ms. Majumdar?
At the court. I do not know.
2019 matter, Vidya? December, January. In the month of so and so on a date to be fixed by the registry. Next.
And I was 16.
Yes,
May I,
workman compensation.
Workmen's compensation. The substantial question of law in this case is the commissioner has assessed the loss of earning on the basis of percentage of disability. He
But why is this matter for orders today? Because substantial
last
question was already framed
yes,
by order dated 25/1/19.
LCR was called for.
Ahi sir, records ahi sir?
Records.
Records ahan hai. And what about respondent numbers 1 and 2?
Yeah, not
No, Mr. Counsel, when matters are placed in the order column, then they are placed for some specific reasons.
Yeah.
Now, it is when we used to be that side, we used to ensure that we look into the file, the office note, so as to assist the court and, save the judicial time.
Yes.
Now, the office note is there, 3/4/2024. It says everything. If this is pointed out immediately, this court will pass the requisite order as required. Heard, Mr.
A.M. Das.
A.M. Das,
A-
Learned Counsel appearing for the appellant. Stop. The office note dated 3/4/2024 indicates that neither unserved notice nor AD card on behalf of respondent number 2 has been received. এইটো নেলিখিবা ৰূপক কি কৰি আছে No such interesting. Unserved notice. Has been not going not known. There was an one and two. I don't think similar. I mean, you to answer, we say one or two. Only one or two. It way, no. Okay. Office note dated 3/4/2024 indicates that the notice on behalf of respondent number 1 has been received along with postal remark within quotes, not known, returned to sender. However, service as regards R2 is still awaited. Mr. So-and-so shall assures that fresh steps shall be taken in respect of respondent number 1. You take it because the address says no such address returned to sender.
Yes, madam.
With the correct address, in the correct address. Huh? Reminder for the trial court records released after 2 weeks on a date to be fixed by the registry.
Deep velvet.
17.
Yes.
I am appearing for the respondent number 2.
What about your counterpart? Why the appellant lawyers are all absent today? None appears for the appellant on call, despite the name of Ms. MS D. Kalita and MS M. Das Gupta being reflected in the cause list. Mr. Your name? KK? Bhatta Learned Counsel is on behalf of respondent number 2 stroke insurance company is present. List after 3 weeks on a date to be fixed by the registry.
May I please your lordship?
Yes, what is this IA?
My
Five-
lord, I
but-
have for delay condemnation, my lord.
What about steps you have taken
My
or
lord,
not?
it is bona fide some mistake, my lord. I have not taken, today I have taken the steps, my
All
lord.
right. You are Mr.
M.K. Sharma. my lord.
Mr. M.K. Sharma, learned counsel for the applicant submits with profuse apologies that due to a bona fide due to an inadvertent missed error, the requisite steps could not be taken. However, the same has been taken today. List after 3 weeks on a date to be fixed by the registry. DPO.
Item 19.
Yes.
I am appearing for the respondent number 3.
Yes. Who's for 3? You are appearing for?
Appellant.
Appellant. And you are for 3. What about the other respondents? Office note R1 and 2. Have you seen the office note or not? So what is the status?
Respondent number 2 has not received the ID card.
Huh?
Has not received the ID card.
Has not received. Did you check? Did you check the office note sheet or not? Then why are you saying yes, yes? Mr. Counsel, see, these are code, right? Why the court speaks to you that way so that you take it with some you see, you have to have some responsibility, no? Now, you have not opened the office note, but you are saying you have seen the office note. Because have you opened the office note, then you would have known that AD card on behalf of respondent number 2 has been received along with a signature and the same is kept on record. So respondent number 2 is complete. However, 1 is still not received. So that's the correct position. Why are you not seeing? Heard, Mr. Your name?
Yes, Bolwal.
So and so, learned counsel appearing for the appellant. Also heard Mr. KK Bhatta, learned counsel appearing on behalf of respondent number 7. Office note date 3, huh? Office note dated 21/6/2025 indicates that service in respect of respondent number 2 is complete. However, await service in respect of R1. List after 2 weeks on a date to be fixed by the registry.
20.
Service completed?
Not completed, Your Lordship.
Huh?
For respondent number 1 is returned without any postal remark. Respondent number 1 is at the place still.
Fresh steps. Heard Mr.
Yes.
S.
Islam.
Islam learned counsel appearing for the appellant. Also heard Mr. AJ Saikia, learned counsel appearing for R2. Mr. Suensu, learned counsel for the petitioner. Appellant submits that he may be request for taking fresh steps in respect of respondent number 1 as unserved notice on behalf of respondent number 1 is still awaited. With
Return back. That is returned back without postal remark.
has been returned back without postal remark. Prayer allowed, relist after 3 weeks on a date to be fixed by registry.
21.
Yes,
Lordship, service is complete.
complete
Lordship, tripod record has not been received. Lordship.
has come.
Not.
Heard Mr. Sharma, na?
Lordship.
S.
R. Sharma.
R. Sharma, learned counsel appearing for the appellant. Also heard Mr. D. Kalita, learned counsel appearing for respondent 1. What about two?
Two notice, Sir Lordship.
It appears
Lordship.
notice.
Office note dated 26/2025.
Office note dated 26/2025 indicates that notice no, service in respect of R2 is complete. No, R1 is complete. Correct?
R2.
So we are appearing for R1.
No, R2 is also complete, Lordship.
So he is appearing for R2.
No, my lord.
R1.
R1.
Sorry. Ulta pulta हुए R2. And reminder for trial court records. Leave list after 3 weeks on a date to be fixed by the registry. Deeply of the Lordship. Appearance or appearance or
Item 22. Thank you, Your Lordship. Lordship, I am for respondent number 1 and 2. The claimant respondent. Appeal has been preferred by the insurance company, Your Lordship.
But where is the appellant? None appears for the appellant on call. Relist after 2 weeks on a date to be fixed by the registry.
Oblige, Your Lord.
And put a claim in method. Notice of the respondent is served.
Miss Majumdar, you're appearing for all the respondents?
No, Lordship, only one.
The other two is received and duly signed. 3 received, duly signed. 4 and 5 received. 6 received. So all served. Except 7 couldn't be served as it has expired.
7.
7 has expired.
Expired.
So that I think has to be,
But Lordship, he was the father of the deceased, so the legal heirs, I think they're there. His wife is
So
6.
maybe
I do not know, but he won't.
then
Yes.
maybe you see if an abetment,
Hmm.
you might have to file a substitution for R7. Because the office note, I'm indicating this and I'm going to adjourn the matter anyway. So you look into it. Heard Mr. K. Sharma, Learned Counsel appearing for the appellant. Also heard MS R. Majumdar, Learned Counsel appearing for the respondent number 1. Office note dated 23/6/2025 indicates that service in respect of respondent number 2, 3, 4, and 5, 2, 3, 4, 5, and 6 stands complete. However, notice on behalf of respondent number 7 couldn't be served as the said respondent in the meantime has expired. Relist after 3 weeks on a date to be fixed by the registry. I'm not saying anything, but you can do the needful if you desire so for bringing a substitution application.
24.
Steps.
Lordship, we inadvertently, we forgot to take step
All
in
right.
the correct, but we have taken, Lordship, on 17/10, we have taken
You have taken on 17.
10.
17.
Office note, Lordship will peruse. Office note dated 10/9/25, where they have said we have not taken.
Okay.
But we have
All
taken.
right. Heard MS R.D. Majumdar, Learned Counsel appearing for the appellant. Ms. Majumdar, so and so submits that though initially there has been lapses, and though initially inadvertently no fresh steps was taken in respect of the respondent number 1 and 3. However, later on the same has been taken on such and such date.
17/10.
So and so. Relist after, in view of the aforesaid assurance, relist after 3 weeks on a date to be fixed by the registry.
Highly obliged.
25.
Yes, case records, Ahisa.
Lordship, unserved notice has been returned as not found.
Respondent number 2.
2, Lordship.
What to do then?
Lordship, we'll have to take steps through paper publication. That's the only way because it's in a village.
Which is that section? A substituted mode of service. Substituted mode of service, which is that provision?
What
It
is
is
Order
there.
5, Rule 9, 5, something like Order 5, Rule 9, 5, it was there. No, it is deemed to be service. That will be on
Order 5.
Order 5 has to be seen, Lordship. Substitution of 20, Lordship.
Hmm?
Order 5, Rule 20.
Yes.
Under Rule 21 to 1A. Whether court acting under sub-rule 1 order service by newspaper shall be a daily newspaper circulating in the locality in which the defendant is last known to have actually or voluntarily resided. Lordship. It's in a village in this Kamrup district only, Lordship. Village Dangpara, Borghuli.
Okay.
So a local
Heard
newspaper in
Mr. P.
Assamese, Lordship.
Bhattakur, Learned Counsel appearing for the appellant.
R. Goswami.
Sorry, R. Goswami, Learned Counsel appearing for the appellant. None appears for the respondent numbers 1 and 3 on call. Office note dated 5/9/2025 indicates that unserved notice on behalf of respondent number 2 has been received along with a postal remark within quotes not found returned to sender, and the same is kept on record at flag A. It further appears that the service report on behalf of respondent number 2 has also been returned from the Office of Civil Judge, Junior Division, Rangya, Kamrup, along with the concerning process server report with the endorsement within quotes, the notice couldn't be served as no such address was found, and the same is also available as available in the record at flag B. In view of the fact, in view of the fact that the respondent number so and so, that the notice against respondent number so and so could not be served in the ordinary, could not be served comma, this court deems appropriate to direct the appellant to take steps by way of substituted service in terms of Order 5, Rule 21A. Stop. Let the notice be advertised in a newspaper, in two newspapers,
In one Assamese
one
newspaper.
Assamese and one English, circulating in the locality in which the respondent number 2 is last known to have actually resided. Correct?
Yes, yes.
Within
Let's say the date of appearance may be fixed as 17/12 because it will take me some time getting the order from
1710
him.
corridor,
17,
steps
12,
to within 1 week. Take it within 1 week, steps. You take the steps within a week.
Within a week.
Huh.
I said, can it be just one newspaper only?
Why?
Yes.
No, 2 newspaper. This is wrong, yeah.
Yes, one.
Yes.
How like this? 17/12.
26.
One local and one English daily code. None appears for the appellant on call on for parties claim. Released after 3 weeks on a date to be fixed by the registry.
27.
May I please, Your Lordship, as per office note dated 15/10/2025, services completed also.
That service to complete his service, I was. Two. Which is the office note, Mr. Counsel?
14/10/2025.
Two, he says he's appearing. What about one? Served office staff accepts notice. So it's complete. Heard Mr.
P. Bora.
P. Bora, Learned Counsel for the applicant. Appellant. Oh, this is applicant. Applicant also heard Mr.
A.L. Mandal.
A.R. Mandal.
A.L.
A.L. Mandal, Learned Counsel appearing for respondent number 2. Office note dated 14/10/2025 indicates that service in respect of respondent number 1 stands complete. Relist after 3 weeks on a date to be fixed by the registry.
Hello.
Item 28.
Completed to yes. Just 1 second. Into item 26 দিলা non appears bill to কৈছা তাৰ পিছত লিখি দিবা office note 28/8/2025 indicates that service in respect of respondent numbers 1 and 2 stands complete.
Item 28.
Yes, temporary injunction.
Yes, my lord.
Why is it for orders?
My lord, I don't know. My lord, we have filed an IA along with the RFN. The IA was to restrain the respondents from making any construction work over the suit land. But we have been informed by the appellant that the respondents have already done some construction work over the suit land. So, my lord, the purpose of the IA has become
Infractious. This IA is 556.
Yes,
Okay. Heard Mr.
S.H. Mahmood,
S.H. Mahmood.
Yes.
Learned counsel appearing for the
appellant.
applicant. Also heard Mr. M. Hawk, learned counsel appearing for the respondent. Mr. Mahmood submits that though the submits that the instant interlocutory application has been filed seeking seeking direction for restraining the respondent to carry out the construction activity in the suit premises. However, in the meantime, he has been instructed by his client that the construction has already been carried out and has been completed.
Yes.
In view of the above, Mr. So-and-so submits that the interlocutory application has become infractious. In view of the aforesaid endorsement made by Mr. So-and-so learned counsel for the applicant, the interlocutory application is dismissed on being infractious. Disposed of. Yeah. Main case to
Maybe listed for hearing, my lord.
records have come. In the main case, records have been received, list for hearing.
For hearing after date weeks.
List for hearing on any date to be fixed by the registry.
29.
In the usual course, for it,
It will be lordship.
Yes,
Lordship, there is a delay in substituting the owner of the vehicle.
this is a delay condonation
Delay conditions for substitution lordship.
for substitution.
Yes, lordship.
And Mr. Goswami, you are objecting to the delay condonation.
5,600.
Huh?
5,600 is delay.
What is the ground?
Ground lordship, out of that 5,600, about 3,000 days were during the trial court, because the judgment was passed 7 years or 8 years after the date of the owner of the vehicle. That substitution should have taken place there itself. We didn't know, only when the notice was sent from the school. That appeared. After that, lordship, we tried a lot to find out. No one was forthcoming with the information. Then lordship, the newspaper publication was also allowed to be. That also, after that also. Then lordship,
Where have you stated all this? Paragraph 3.
Paragraph 3, lordship. Then of course, I must thank my.
Mr. Goswami, the number of delay days is not the criteria. Sometimes even 5 days of delay may not be condoned.
Sometimes I appear in this side, so I cannot.
No, that's what I'm saying. You see, it's a liberal approach and it's a substitution application. Now the reasons appears to be bona fide. That's the requirement. The number of delay is not the criteria.
And lordship, even further, I must thank my learned friend only.
Yes, yes.
Without his help, I would not have been able to find.
Acha. See? Okay. Heard Mr. R.K. Goswami, na?
R. Goswami.
R. Goswami, learned counsel appearing for the applicant. Also heard Mr. S.K. Goswami, learned counsel appearing for the all respondents for respondent number?
Respondent claimant.
Respondent claimant. What about the other respondent?
1, 2, 3, I request, because 4 is the owner and 4 has been substituted.
Okay. Uh, by way of this interlocutory application under Section 5 of the Limitation Act so and so, comma, the applicant is seeking condonation of delay of 5,600 days in filing the application for substitution. It appears that during the pendency of the connected appeal being so and so, a MAC appeal number 158 of 2015, the respondent number 4 died on 28/8/2007, and his wife Srimati Ila Das also died on 8/10/2021, leaving behind his legal heirs / representatives. Accordingly, the legal so and so has filed the connected substitution petition, i.e., give me the number of the substitution petition, I so and so.
Yes.
However,
1/5 of 2023.
so and so with a delay of so many days. Right, ba? The grounds of delay as stated in the appeal, as stated in the application reads as under paragraph 8, page 4. Paragraph 3, paragraph 4, paragraph 5, paragraph की तरह उल्टा है, तो ऐसे दिन लगे 6 and 7, 6 वाला कितनी? Reading of the aforesaid so and so, heard the learned counsel appearing for the parties, perusal of the aforesaid grounds as stated as expected above, appears to be bona fide and sufficient. Delay so and so's condoned. Registered is already registered. The IA is substitution.
Either is.
Okay, then allow corrigible substitution or where is the IA? This is disposed of condonation.
It's 1290 and 1290.
Objection to similarly allow corrigible. Parties will be the same. Application is under order to yet permanent. So and so substituting legal heirs of respondent number 4, Namgita Okon Rajbansi in MAC appeal number 158/2015. A first part to similar hobo about the death and all that. And third episode, instead of the condonation, you say accordingly, the who is he? Who is the respondent? Who is this Okon Rajbansi?
He was the owner of the.
No. Who has filed? Oh, these 3 persons. Accordingly, they are the 3 children.
Yes, Lordship.
1, 2, 3. Who has come now?
Yes, Lord.
The 3 children. Accordingly, the 3 children of so and so, A Okon Bakshi and so Mako Nam to has filed the instant substitution application. Details, paragraph 3 sir. Allowed registry to amended cost title and registry to the needful.
Then 1291 is also given, setting aside.
1291 is for?
Or cancellation of abatement.
I think this should have been
Yes, Lordship.
prior to the substitution. So A2 order to deliver
Yes.
allowed.
Lordship.
মই এবাৰ দেখুৱাই দিবা মই ঠিক কৰি দিম
Item 30.
নাম্বাৰছ কিটা খালি ভালকে লিখি ল'বা নহ'লে abatement কোনটোৰ হেৰিটো yes
Service upon respondent number 2 is not complete. It was returned. Address insufficient.
address is served.
Address insufficient.
Yes, so then you take
I
sufficient.
take steps.
All right. As prayed for by Mr.
R. Sharma.
R. Sharma, learned counsel appearing for the applicant, list after 3 weeks to enable the applicant take fresh steps as
Sufficient.
To furnish the sufficient address before the registry in order to complete the service in respect of the respondent number two.
Obliged.
32.
Restoration.
I'm appearing for respondent number 5,
Is this a restoration application?
my lord.
Where is the applicant for restoration and again not appearing? None appears for the petitioner, none appears for the applicant on call, despite the item number, 32. Despite the name of the learned counsel appearing for the applicant being reflected in the cause list. Mr. T. Kolita, learned counsel for the respondent number 5 is present. It appears that by way of this application under Order 9, Rule 9, read with Section 151 CPC as amended up to so and so is seeking restoration of IA Civil number 2496/2023 in MAC appeal filing number 9874 of 2023 to its file, which was dismissed for default on 9/5/2024. However, despite the aforesaid application being for restoration of the connected MAC appeal, which was dismissed for non-appearance earlier, today when the restoration application has been called, there has been no appearance, no representation on behalf of the applicant on call. Considering the above, the restoration interrogatory application stands dismissed for non-prosecution.
Much obliged.
34.
Wait, is this your lordship? Lordship, in this case, we were allowed to take steps by newspaper publication, lordship, that we have done. The affidavit is marked as flagged affidavit of service, lordship, on respondent number 123.
So a newspaper publication that has been done,
Done, lordship.
but there is no appearance today. So I'll record this and give a date.
But lordship, it is delay petition, only 17 days delay.
I'll condone the delay then.
Yes, lordship, that can be done. Because again in appeal, we will
Okay,
be taking.
let me just first let me take up this has been done in IA only, no?
Yes.
This IA itself is the delay condonation.
Yes.
Where is the paper publication?
Lordship will find it affidavit of service flag,
Where is that? Yes.
affidavit of service.
17 days, na, Ms. Majumdar?
Yeah.
It was published on 12/7.
Yes, lordship.
Okay.
Then on the last date, we were given time, this affidavit was not on record.
All right,
so-
got it. Heard MS RD Majumdar, learned counsel appearing for the applicant. Stop. None appears for the respondents on call. This application is filed under section, this application is filed under section 173 of the MB Act, read with section 5 of the Limitation Act so and so, seeking condonation of delay of 17 days
Yes, lordship.
in filing the connected appeal against the judgment and award dated 6/1/2024, passed by the learned member Motor Accident Claims Tribunal number 2, Kamrup M, Guwahati, in MAC case number 2439/2017. Stop. Pertinent that,
From paragraph 3 to 7. lordship.
one
Next,
second,
please.
one second. That since the service of notice upon the respondent numbers 1, 2, and 3 was returned unserved with the endorsement within quotes addressee left, this court on 25/4/2025 allowed the prayer of the learned counsel appearing for the applicant to cause service upon the aforesaid respondents by substituted mode of paper publication. Stop. The additional affidavit dated 28/7/2025 filed on so and so, not dated, filed on so and so, by the applicant indicates that the notice was published in Doinik Okhom on 12/7/2025. It appears that despite the notice being, and do you have a copy of that notice? Is it there?
It's in the newspaper itself, Lordship. Original newspaper is.
Perusal of the notice as carried out in the aforesaid newspaper, it appears that despite the respondent being intimated as regards the next date of hearing, however, there has been no representation on behalf of the respondents till date. Stop. Be that as it may, it appears that the issue involved in this interlocutory application is condonation of 17 days of delay. Accordingly, this court, in the interest of justice, proceeds to consider the prayer made in this interlocutory application ex parte. Yes, where are the reasons?
Lordship, paragraph 3 to 7, Lordship.
The grounds of delay as stated in the so and so reads as under paragraph
3 to 7.
3 to 7. Perusal of the aforesaid grounds appears to be sufficient and bona fide condoned. Now, what is the next? This is delay is condoned,
Yes, Lordship.
and then we are connected.
Registry will register.
Has to be registered.
Yes, Lordship.
So registry to register and list it for and list before the bench
Admission.
for admission.
Highly obliged.
Happy Lordship. Lordship, this I is for condemnation of delay, 14 days been in finding.
How many days?
14 days.
14.
Lordship, only thing is. Lordship,
Service is still awaiting.
No, Lordship, notice could not be served, Lordship. Can you
Why?
serve Office note dated 18/9/2025, Lordship. 18/9/2025.
That which also happened to be the fixed date for next listing. What does it say? Service report has arrived with a statement that notices were received by their office on 13/11.
Lordship,
Also, they probably need more time.
Lordship.
So I'll say await.
Or I will take fresh step, Lordship,
Okay.
on usual process again, Lordship.
Aspirate office heard Mr.
Asham.
R. Sharma, learned counsel appearing for the applicant. Office note dated 18/9/2025 reads as under page 2 of the office note, quote unquote. Mr. So and so seeks issuance, seeks liberty to take fresh steps in respect of respondent number
1 and 2.
1 and 2 by usual process. Prayer is allowed, relist after 3 weeks and a date to be fixed by the registry.
Obliged.
This 6.
174 days.
Yes, your lordship, but so far opposite party number 1 and 2 is concerned, who happens to be the driver and owner and driver of the vehicle. Service is awaited. No report is there.
Okay, await service in respect of 1 and 2, relist after 3 weeks on a date to be fixed by the registry. By then, if nothing comes, then we'll proceed. And MS,
M. Saikya.
M. Saikya is present for R2.
Respondent number
three.
3,
3
Lordship.
is present for R2.
Oblige.
120, 1,226 days
20.
delay. Yes, service complete, not complete.
Await.
Await service. List after 3 weeks on a date to be fixed by the registry. Yes,
LCR has been received, my lord.
received.
Yes, my lord.
So the FAO can now be fixed for
Hearing.
hearing.
Yeah. And
Heard Mr.
yes, sir, come with.
S. Saikya, learned counsel appearing for the petitioner. Also heard Mr. I. Iqbal.
A.
Iqbal. Iqbal, learned counsel appearing for respondent numbers.
Sole response, sole.
For the sole respondent. It appears that the trial court records have been received. List for hearing when?
Past week of December.
In the month of November on a date to be fixed by the registry.
Mile. Deeply of this.
Mr. Iqbal, what does A stand for?
Asif.
Now I remember your name.
My lord wants to amend my name.
Huh?
My lord wants to amend my name.
No.
A for amendment.
There was a confusion. That's why I've been repeatedly referring you as a different initial. So,
It's okay.
yes.
Lordship, the petitioner hearing has expired. We have filed an IA for.
You have filed or you want to type? Huh?
Lordship, we have already filed an IA for substitution.
This is the substitution, the 2568.
Yes, your Lordship.
Any delay?
No, Lordship.
Abetment? No.
No, Lordship.
Yes.
Don't have any objection.
All right. Heard MS
K. Bhattacharya.
K. Bhattacharya.
Bhattacharya.
Learned counsel appearing for the applicant. Also heard MS.
A. Kharbani on behalf of D. Chaudhary.
A. Kharbani, learned counsel appearing for
D. Chaudhary.
on behalf of D. Chaudhary. Learned counsels appearing for the respondents.
All the
All
respondents.
the respondents. By way of this application under Order 22, Rule 3, read with Section 151 of the CPC, the applicant is seeking substitution of the legal heirs of the sole petitioner. It appears that during the pendency of the revision petition, the sole petitioner has died on 2/1/6/2025, leaving behind the following legal heirs 1, 2, 3, 4 at page 4.
Lordship, the petitioner died on 1/6/2025. Page number 4 of the IA.
Yes,
Lordship.
Makmaki did look. Oh, sorry, 1/6/25. In view of the aforesaid development, the present application has been filed. Allowed. Substituted.
Lordship.
Yes, why is this for orders?
My lord, service report has not been received, my lord.
Huh?
Service report has not
Okay.
been received.
Await service.
In the meantime, my lord, stay order may be continued.
Huh?
Stay order may be continued.
Given earlier.
Yes,
Where is the stay order?
190925.
Stay, if any stay, then to continue. Done.